We have formulated 4 questions. The first question is whether the permanent committee has the authority to withhold or defer an advocate's name from being submitted to the full court following the interaction stage as prescribed by Rule 6.5 of the 2019 rules. And we have answered as follows. Therefore, the permanent committee's role is confined to making an assessment and submitting a comprehensive assessment report to the Honorable Full Court for consideration. It does not have the authority to make final decisions on designation or exclude candidates from consideration based on its recommendations. The permanent committee does not possess the discretion to withhold, eliminate, or defer the name of any advocate at this stage. The withholding, elimination, or deferral of an advocate's name after scrutiny falls outside the permissible functions of the permanent committee. Specifically, Rule 6.6 requires that all names considered by the permanent committee, together with its assessment report, be submitted to the full court. This provision does not grant the permanent committee the authority to restrict submission to only those names meeting a specified cutoff score, or to withhold, eliminate, or defer any candidate's name following the interactions mandated by Rule 6.5. Actions contrary to these requirements would violate the provisions of Rule 6.6 of 2019 rules. Question number 1 is answered accordingly. So far as the question number 2 is concerned, it is whether the permanent committee possesses the authority to exclude the names of certain advocates from consideration based on the points they have secured in the overall assessment. And we have answered like this. The committee is not authorized to forward only the names of those who meet the cutoff score to the full court. Additionally, the High Court has not delegated such jurisdiction to the permanent committee to eliminate candidates based on whether they scored below 70 points according to the point-based format in Appendix B, unless explicitly provided in the 2019 rules or granted to the committee the imposition of a 70% cutoff for submitting applicants' cases to the full court for senior advocate designation is not justifiable. Merely notifying the full court about the adoption of a 70% cutoff point is insufficient. Question number 2 is answered accordingly. Then the question number 3 is, in light of the petitioner's fresh application in response to advertisement number 1 dated 22/4/2019, which adhered to the 2019 rules and included the invitations of suggestions and views on his name under Rule 6.3, as well as his submission of reported and unreported decisions, articles, and particulars, and his participation in the interaction on 18-10-2019. Was the Permanent Committee justified in deferring his case on 23-10-2019? We have answered as follows. Following the division bench order dated 15-10-2019, the petitioner attended the interactions on 18-10-2019. It appears that the Permanent Committee's decision to defer the petitioner's case was not communicated to the division bench overseeing the matter. Such communication should have occurred. Consequently, it is our view that the Permanent Committee should not have deferred the petitioner's case on 23-10-2019 after the interaction held on 18-10-2019. If the Permanent Committee acquired any new information post-interaction with the petitioner that could adversely impact such candidacy, such information should have been presented to the full court along with the overall assessment conducted by the Permanent Committee. At a minimum, such information should have been disclosed to the court. In light of this consideration, it is our view that following the petitioner's interaction on 18-10-2019, the Permanent Committee should not have deferred his case on 23-10-2019. Question number 3 is answered accordingly. The last question we have formulated is like this. Given the division bench directive in the judgment dated 10-5-2021 in the aforementioned two writ petitions, which mandated the consideration of all 48 applications, including that of the petitioner and the opposite parties number 5 to 9, should the petitioner have been excluded from participating in the second interaction based on the prior decision made on 23-10-2019, we have answered as follows. There was no justification for excluding the petitioner from participating in the second interaction on 24-4-2022 based on the prior deferral noted in the counter affidavit filed by the opposite parties. If the Permanent Committee believed that deferring the petitioner's case was warranted due to newly obtained information, it should have sought a modification of the judgment, specifically addressing paragraph 32 Roman 3. Without such a modification, the petitioner should not have been barred from participating in the second interaction solely on the basis of prior deferral. Thus, the deferral of the petitioner's case could not be extended indefinitely. Question number 4 is answered accordingly. Now we have come to the conclusion. Having addressed all the questions in favor of the petitioner, we would ordinarily have directed the Permanent Committee to submit the petitioner's name to the full court for consideration for designation as senior advocate following an overall assessment and the point-based format as per Appendix B of the 2019 rules. However, it has come to our attention through the counter affidavit filed by the learned Registrar General of this court that advertisement number 1 dated 8-5-24 has been issued inviting applications for senior advocate designation several advocates have already submitted applications in response. According to the notice dated 7/8/2024, advocates are requested to rectify any defects or deficiencies in their submissions within 2 weeks from 8/8/2024. Additionally, the registered judicial's notice dated 7/8/24 indicates that the petitioner has also been asked to submit a fresh application in the new format, that is form number 2 of Appendix A of the High Court of Orissa Designation of Senior Advocates Amendment Rules to 2023 within 2 weeks from 8/8/2024. During the proceeding, the petitioner indicated that he had refrained from submitting a fresh application due to the pendency of this writ petition, fearing that it would render the petition infructuous. Nevertheless, he expressed his willingness to file a fresh application and requested that his name be considered without further deferral. He also sought a reasonable extension of time to submit the application, acknowledging that the original deadline had passed. The London government advocate has raised no objection to this request. In light of this consideration, we dispose of the writ petition with the following directions. The petitioner shall submit a fresh application in the new format, that is Form 2 of Appendix A of the High Court of Orissa Designation of Senior Advocates Amendment Rules 2023 within 2 weeks from today. Upon receipt of the fresh application, the permanent committee shall proceed in accordance with Rule 6 of the 2019 rules as amended by 2023 amendment rules. The committee shall conduct an overall assessment and submit the petitioner's name to the Honorable Full Court along with its assessment reports. Before concluding, we wish to acknowledge and express our deep appreciation for the meticulous preparation, presentation, and invaluable assistance provided by the petitioner, Mr. Banshidhar Bagh, and Lenin government advocate, Mr. Jyoti Prakash Patnaik. I agree.